Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is the minimum amount of days required for notices of non-renewal to terminate tenancies here in Maryland. And I am Brian Pendergraft, and I'm an attorney that is licensed to practice law in both Maryland and the District of Columbia, and I work for the aptly named the Pendergraft firm, LLC. Quick disclaimer, this is legal information. This is not legal advice. For legal advice, you can contact an attorney that is licensed to practice law in your jurisdiction. That said, if you are in Maryland or DC, consider contacting the Pendergraft firm. More disclaimers. So if you are watching this video anytime after the upload date, it's possible that the law may have changed, and thus the amount of days required to send a notice of non-renewal may have increased or decreased since the timing of this video. I will put a link to the law that I am referencing in the description, so you can check that. You can check the link to see if anything has changed. I'll do my best to try to, perhaps do an update video in the future if that happens, but I can't promise I'll do that. So make sure that you verify what I'm saying here with the actual law. Point number two, another disclaimer. So this is based on my possible flawed interpretation of the statute. So this video is, that said, this video is not a substitute for the law. So what I have to say, in other words, what I have to say here is not the law itself. It is not so it shouldn't be used in place of, you shouldn't cite this video, and you should cite the law when making legal arguments. Don't cite my video. And another quick disclaimer is that this video only covers statewide Maryland law. So it's possible that at a county level that your county may have imposed, or city, your county or city may have imposed additional requirements in addition to what is required by statewide Maryland law. So in other words, Baltimore City may require, let's say, 75 days instead of 60 days or something. I don't know. I'm just saying that. But my point is that your city or your county may require additional notice over, above, and beyond what the state notice requires. So you definitely want to make sure that you comply with your county's requirements as well. This video is only, or city requirements. This video only covers Maryland law. So before going any further, please like and subscribe if you like this. If you like this kind of content, well, if you're on YouTube, if you hit that like button, help boost my video, which helps boost my business, which I appreciate. And if you subscribe, you'll get more, I guess, property law and business law content like this. So that's your speed, then I'm your guy. So why is this important? A landlord must give a proper notice to terminate tenancy, and it must expire prior to filing a holdover action if their tenant overstays their welcome. And if you give an improper notice, the clock starts over and you have to send another one. So yeah, it'll end up being a long time for you to evict the tenant, and we don't want to do that. So and it's also important is because this law changed. I want to say it changed on, I think it came into effect November 1st, if I recall correctly. And since that law has changed, some landlords have still been, I guess not everyone is up to speed on what's going on. So some landlords have still been sending 30-day notices to vacate. And what happens is that when they go to court, they end up losing the case because no one told them that the law has changed. So it's unfortunate, but that's why this is important. So that said, let's see. So where are we at now? So, all right, the next slide is the minimum amount of days that you must send a legal notice prior to the expiration of the term. Now, there are different kinds of terms according to that the statute addresses. So, and I have them all here. There's, week-to-week tenancies with no lease, week-to-week tenancies with a lease, month-to-month tenancies, year-to-year tenancies. And depending on the type of tenancy that it is and whether or not there is a written or no lease agreement, the amount of days in order to send a notice to terminate tenancy may change. Now, that said, this is the minimum amount of days that the notice needs to be sent prior to the end of a term. Now, what that means is that, for example, if I have to send a 6-day notice to terminate a month-to-month tenancy, what that means is that 60 days is it's 60 days before the end of the term. So a notice that I sent, so today is March 13th. So if I send a notice today, it is not and let's say there is a month-to-month tenancy, and I want to end a month-to-month tenancy, and let's say the tenancy is already expired, but I never sent a notice. So and then after that, that tenancy defaults to month-to-month. So if I send the notice today, 6-day notice, or if I send a notice to terminate tenancy now, um, 60 days from March 13th that is May 13th. So if I send just a 6-day notice and month-to-month tenancy, that notice is technically under statute. That notice is not effective because it's not 60. Because the term, assuming that the lease terms begin on the first, that means I would have to essentially give 2 months of notice. So it's going to have to be 60 days prior to the term that I wish to terminate. So a notice that I send today on March 13th will be effective on not May 13th, but May 31st. So that's what I mean by the minimum amount of days prior to the expiration of the term. So essentially, you're going to have to make sure that you select the right date. And remember, it's not 60 days; it's 60 days prior to the expiration of the term. So they could end up getting more than 60 days, essentially. Um, in the case of month-to-month tenancies. So make sure that it's 6 days. You send a notice, not just the exact amount of days, but the amount of days that are prior to the expiration of that term. All right. So starting with point number one, that is week-to-week tenancies without a lease agreement. So the amount of days required to terminate such a lease agreement is 21 days. Point number two, week-to-week tenancies with a lease agreement. So 7 days prior to the expiration of the term. Number three, month-to-month tenancies and tenancies greater than 1 week with or without a lease agreement. Minimum amount of days is 60 days prior to the expiration of the term. Year-to-year tenancies and tobacco farm tenancies. The minimum amount of days is 90 days prior to the expiration of the term. All other farm tenancies, 180 days. So point number six. So this is if a landlord relies on a tenant's notice of non-renewal. So if a tenant sends you a notice of non-renewal prior to the expiration of the term, and well, I guess for the expiration of the term. Now, if it is a month-to-month lease, then they can send a 30-day notice, and the landlord has to rely upon that notice. So the tenant says, "Hey, man, I wish to terminate," and they send that to the landlord, and then they stay and don't leave. Then then the landlord can go file a holdover action using the tenant's notice, essentially. Now, again, that is for month tenancies, it's 30 days. Year to year, that's 90. For farm tenancies, that's 180 days. So the in point number seven, that is if a small landlord, and by small landlord, you see I have that defined as landlord with 5 or less properties in Maryland. So if they receive a notice of intent to foreclose, except from Baltimore County, Montgomery County, essentially what that does is, I guess, because the law sees, because the landlord is under the pressure of a foreclosure action, it actually reduces the amount of time that a landlord has to send a notice to notice to terminate tenancy. So it becomes, so for a month-to-month tenancy, it becomes a for month-to-month for less tenancy, it goes from 60 days to 30 days, or from a year-to-year tenancy, it goes from 90 days to 60 days. And point number 8 for squatters, which the statute doesn't cover because it's not really need to. So there are squatters do not have a right to a notice to terminate tenancy in Maryland. So no notice is required. That said, I still like to send, if I know that they're squatters, I still like to send a notice anyway and just tell them to get out, just so I have proof that I, sent them something. Alrighty, well, that I can use later in court, that, hey, I did ask him to leave. So even if there is squatters, I would still send a notice telling him to leave anyway. Um, Alrighty, additional related info. Lease terms that require less than the minimum amount required by Maryland law will not be enforced. So there's a lot of old leases that say 30 days, and a lot of those old leases judges are not going to abide by anymore. So you may want to update your leases. If you have an old lease, it may be time to update it to make sure that it complies with Maryland law. Now, if you would like that service, consider contacting the Pendergraft firm. So Additional related info. Point number two: after your lease expires, you can file a holdover action if the tenant is still there. So I have a video on holdover actions that I will post in the description. Point number three: I like to send notices to terminate via United States Postal Service priority mail. So I have proof of delivery. And that's why I like priority mail. Yeah, I get proof of delivery, and I can use that proof of delivery in court. Point number four: a guest that starts paying rent probably becomes a tenant. So don't end up creating tenancies by accident. And point number five: you can send the notice yourself, but if you would like to hire an attorney, then I and the Pendergraft firm is available to do that. You can contact me. So thanks for watching. Again, my name is Brian Pendergraft Esquire with the Pendergraft firm. And yeah, do I really need to? Yeah, you see everything on the screen, how to contact me. So yeah, follow me on Instagram, I guess, at the Pendergraft firm. All right. And thanks for watching. And like, subscribe, all that good stuff. All right. Take care.